So hi, again, my name is Kara Kaikini. My pronouns are she, her, and hers. I'm the board president of the Maine State Breastfeeding Coalition. We should have a pretty good sized group here today, not just from Maine, but from all over the country. So please feel free to use the chat box to share where you are joining us from. And if you haven't already, please get familiar with your Zoom functions and know that you can enable closed captioning for yourself. It will be included in our recording as well. And since we have so many folks here today, it might be best if you keep your camera off during the presentation. And if at the end, there will be a Q&A session, and so you'll be welcome to ask your question. You can turn your camera back on for that. And you can also adjust your view so that it just includes Attorney Tozier and her screen. The recording, just so you know, will be available on our YouTube page, and I'll put that link in the chat box in a bit. So welcome to the second educational webinar of our 2023 series. Our next webinar will be on June 1st, and that will feature Dr. Jessica Rosenthal, who will be speaking about breastfeeding and human milk and the microbiome. And in August, we'll have Dr. Julia Fritz and Virginia Weil speaking from Maine Medical Center about understanding feeding challenges from a gastroenterologist and speech and language pathologist perspective. That will be really interesting. I've heard them speak otherwise, and I think it'll be really good information for us. And stay tuned for registration info about those upcoming webinars and other opportunities we have coming up. If you do not want to be added to our mailing list, if you're not already on our mailing list, and if you registered for this, we will go ahead and add you to our mailing list unless you would not like to do that. If you would not like that to happen, then please send me a private message or send an email to mainebreastfeeds@gmail.com, and we will be sure to not add you or remove you if needed. So I am so excited to introduce our presenter today and to hear her presentation. Attorney Allie Tozier specializes in employment law. She has helped both employers and employees navigate workplace laws and challenges for about 8 years now. And Attorney Tozier grew up in Falmouth, Maine, and graduated from Williams College in 2009. She lived and worked in various places, including London, before returning to her roots. She graduated from Maine Law in 2015, where she became enchanted with employment law during an internship at the Maine Human Rights Commission. She has practiced in Portland ever since and recently joined Bennett Law Firm. Attorney Tozier has been named a Super Lawyers Rising Star 6 years in a row, was appointed by the governor to Maine's Board of Bar Examiners to help safeguard the legal profession in 2018, and is an American Bar Foundation Fellow, a former district representative in the American Bar Association, and chair of the Maine State Bar Association's New Lawyers section. She has a leadership role in 2 local organizations that encourage diversity and inclusion in Maine. And we are very proud to say she's also a volunteer with the Maine State Breastfeeding Coalition. Some of you may also know Attorney Tozier's mother, Pam Tozier, who is regarded as one of the state's leading lactation consultants and has inspired her daughter to help workplaces become more accommodating to the needs of nursing parents. Thank you for that, Pam. Attorney Tozier also lives in Portland with her dog and enjoys salsa dancing, being in the mountains of New Hampshire, and spending time on Buston's Island and Casco Bay, where her family has lived every summer since the 1930s. So welcome, Attorney Tozier. Thank you so much for being here.
Thank you, Kara. It's a pleasure to be here. I'll also give a shout out to my sister and sister-in-law who do a lot for lactation as well. So it's sort of in the family, this issue. And I want to say that I actually came from the one employment law conference that we have once a year, where employment attorneys in Maine who represent both sides, who represent employers and employees, they all come together once a year, and today's the day for that. So I actually scooted out of that meeting to come do this, and I'm going back to that. But this morning, there was a lot of talk about lactation and employment law and what's going on in Maine. So this is a very timely topic. The laws have changed recently, which we're going to talk about. And I'm really happy with the direction that the laws are heading. But as I was reflecting on this presentation and what to talk about, I wanted to think about where we've come and why we are where we are in our history and where we're going. So that's how I've sort of structured the presentation. And at the outset, I want to say that there have been a lot of developments, but one of the developments is with gender, right? So it's not just an individual who goes by her and she for pronouns that's going to be a nursing parent anymore. We have anyone from any gender can be that, and we want to be sensitive to that. In fact, the Maine Human Rights Commission talked about that this morning at that conference, that we need to keep that in mind and how we speak about these issues, and they're leaders in that. But it is easier sometimes to use the pronoun she when we're talking, or mother. So you'll probably hear me say that in this presentation. I just wanted to put that out there, and I appreciate that our culture is evolving in that way. Let me just. Okay, so here's the agenda for today. And Kara, if you find that I'm unable to be heard or there's issues with the connection, just let me know, okay? I think
good.
Okay.
So fine. Yep.
Okay, great, wonderful. So we're going to talk a little bit about where we've been just as a nation when it comes to women in the workplace, because it leads into the protections that women have in breastfeeding and being pregnant and working, and in lactation rights and being able to take time to express milk at work. So we're going to talk about where we've been, where we've come, the laws that have been in place, what's new, why is this a hot topic right now, and where we're going and what needs to happen to continue to improve. Okay, so I just want to start by talking about the importance of breast milk for babies. I know a lot about it because of what we talked about with my family, and most people on this call probably do as well. But according to the CDC, breast milk, is the best source of nutrition for most babies. And as the baby grows, the mother's breast milk will change to meet the baby's nutritional needs. It can help prevent against illnesses or disease. We also live in a world where nursing mothers work and need to pump milk while at work. So I want to examine the laws that protect the right to do just that. It's been a challenge for many people, for many parents to find the balance and to be able to feel like they have the ability to do both, to provide breast milk for their children and to keep working. So where have we been in the past? Well, it used to be, as we all know, that a woman's place was in the kitchen and the man's place was around the table making the business deals, and the two worlds didn't overlap. The women, didn't need these protections back in the day because they weren't working and they would just be at home with the kids. So that's where, and that wasn't that long ago, if we really think about it, that's what this world looked like. But I put this poster here, that We Can Do It poster, Rosie the Riveter. It came out in 1942. And, this was, when women started to join the workforce, they needed women in the workforce because of the war, because of World War II. And there was a big shift of, okay, women can start working now. And it really changed the tide, of women in the workforce. That's where I see it as really beginning. And then we see from the 40s onwards, this huge wave of women entering into the workforce, and then needing, more rights, equal pay, and the ability to express milk at work, and accommodations for pregnancy. All of that came, of course, with the evolution of the women's role in the workplace. And I thought this was interesting from the Library of Congress's website. Just a little background about the We Can Do It poster. It was just a publicity campaign, that really changed the minds of women and encouraged them to change their roles in society. I thought it was interesting also to look at, what year were women actually able to go to college, which of course relates to them being able to work and to have certain types of jobs. And you know, most people know this, but it's interesting to reflect on this in relation to when the laws were passing for women's rights in workplaces. You know, it wasn't until until the 60s, that were the later 60s, the 70s, and even the 80s that women were even admitted into colleges. And I have a list here of some of the top schools in our country. You know, and it was 1977, for instance, when Harvard allowed women to go as well. So it's important to reflect on this when we're thinking about the progress that's been made and the timeline of it. So one interesting statistic is that as of spring of 2021, women have made up 59.5% of all of US college students. So that's been a record high. You know, we have more women than ever going to college. We have lots of women in the workplace now, but it really wasn't that long ago where that wasn't the case. So this has all happened rather fast if you think about it. Here's a timeline of some of the laws, and I thought it was interesting to reflect on that in relation to women's ability to go to college and work like men. So on June 10th of 1963 is when the Equal Pay Act went into effect, and that is actually part of the Fair Labor Standards Act that already was in existence, and it amended the FLSA to protect women and men to perform who perform some substantially equal work in the same establishment from discrimination based on wages or sex-based discrimination in their wages. And of course, we still have, that was 1963, it's 2003, it's 2023 now, and we still have an issue with equal pay, but I think that's interesting to think about. It's been on the books for a while now, and it's still an issue, but of course, there's been lots of progress on that point. And then on July 2nd, 1964, that's when Title VII of the Civil Rights Act of 1964 came into being. And it was a law that President Johnson signed in order to prohibit employment discrimination based on race, sex, color, religion, and national origin. And the Act, Title VII, as we call it, it also created the EEOC, the Equal Employment Opportunity Commission, to enforce Title VII, and its goal, the EEOC's goal, is to eliminate unlawful employment discrimination. So that is when that came into being. Of course, different states have enacted their own versions of Title VII. For instance, ours is the Maine Human Rights Act, which I'll talk about a bit later on in the presentation. And the state laws will mirror the Civil Rights Act, but also have, most of the time, have more protections delineated in the state laws. So there's more what are called protected classes, like sexual orientation is a new one, for example, that Maine has in the Maine Human Rights Act. But you know, we're focusing today on sex and pregnancy and lactation. It's really about lactation, but a lot of cases that relate to pregnancy and lactation have come through Title VII claims, and plaintiffs have brought them, you know, on the basis of their sex, being female. Of course, as I talked about in the beginning of the presentation, you know, it's not just people who identify as female who have those protections. So then, fast forwarding to October 31st of 1978, we had, and this is all federal in this slide, of course, we had the Pregnancy Discrimination Act of 1978. This act amended Title VII, and it made it clear that the term "because of sex" would include on the basis of pregnancy, childbirth, or related medical conditions. And so this was, you know, this was trying to make it so that it was obvious that the employers should not discriminate against people who are pregnant, and any kind of condition related to the pregnancy. So that, is still in effect today, but the law that recently came out that still actually hasn't gone into effect that I will talk about takes that further, and we'll get into that in detail. July 26, 1990 is when the ADA, the Americans with Disabilities Act, came into being in our country. And this law requires employers to provide reasonable accommodations. And it also, it also mandates that there's no discrimination on the basis of disability in the workplace. And so we'll talk more about reasonable accommodations because the new law that just came into being elaborates on that as it relates to parents who have become pregnant, have had a child, and need to breastfeed the child and express milk at work. This is all connected to the new law that came out. It expands on the ADA. And then on February 5th, 1993, that's when the Family and Medical Leave Act, or we call it the FMLA, was enacted in our country. And most of you know about all of these laws already, but the FMLA guarantees eligible employees up to 12 weeks of unpaid leave each year. So the leave is not mandated to be paid. And you might have heard there's discussion in the Biden administration in particular to change that to require paid leave, but that's not the case in our country yet. But right now the law is that they're required, if there are 50 or more employees in that company, they're required to give up to 12 weeks of unpaid leave for the care of a newborn, and other reasons as well. And pregnancy is included, in this, but we won't go into all the details there. Let me just check my notes here. I wanted to state too that, it's interesting in thinking about FMLA and the rights of mothers in our country. There are 193 countries in the United Nations, and just a few of these countries do not mandate paid parental leave, and the US is one of the very few that doesn't. So we're sort of behind the rest of the world in that. And it's important, because a lot of parents, a lot of mothers have, they struggle going back to work right after they have a child because they have to, right? They have to make money. Oftentimes they can't afford the unpaid time off. They need to make money. So think about how that impacts a mother's ability to breastfeed and to give her child the actual food. The breast milk that we've talked about earlier is better for the child and has been shown to prevent against illnesses. It's a very sad thing to think that so many people in our country don't have that option or struggle with the ability to give their child what they want. On March 23rd, 2010, there was an amendment to the Fair Labor Standards Act. And this is when the law federally stated explicitly that employers in the United States needed to provide a reasonable break time for employees to express breast milk. And this is the language of the law. I put it right there for you. For her nursing child for 1 year after the child's birth, each time the employee needed to express the milk. And then also the employer is mandated to provide a place that's not a bathroom, that is shielded from view and free from intrusion from coworkers and the public. And let me also say, I meant to say this in the beginning, that I do have time at the end for questions. So if you have questions that come to your mind about any of this or anything you want to discuss, please write it down, and then there'll be time to talk, and I'll have you unmute yourself and ask your question. So this law that amended the FLSA, it allowed for an employee to request this from their employer and work with the employer, but they're really was difficulty in seeing this change, right? It was 2010, and so 13 years later we have these new laws that have just come out that elaborate on this and expand it, and I'll talk about that again in a moment. But so it's good that this law was in effect, for the last 13 years, but it wasn't good enough. And we're probably going to have to keep making the law better. But this was a start, right? To require that employers provide these breaks and provide a private place. And then there's also the requirement, not to retaliate against employees for standing up for their rights, and for asking for what they need. I'll also say that this is the federal law. So the state laws do have some more protective laws. And it's always the case that you're going to go with the law that's the most protective for the employee. In Maine, and I noticed in the chat, a lot of you said that you're from Maine. As I mentioned earlier, it's the Maine Human Rights Act that governs, the rights or the obligation for employers not to discriminate against people who are pregnant or anything related to pregnancy, including lactation. And I put the statute there if you want to read it yourself, in Title V of Maine's code. But what it says is that you as an employee have the right not to be discriminated against on the basis of your sex, and sex is defined to include pregnancy and medical conditions that result from pregnancy, which is then elaborated on to include but not limited to lactation, including but not limited to lactation. So it's nice that the Maine Human Rights Act puts that out there. And so basically what this means is if an employee in Maine feels discriminated against at work, and the employer does not fix the problem or issue the right corrective action, then the employee has the right to file a claim under the Maine Human Rights Act, and go through the process to try to get compensated for that. And like I said too, there's no retaliation allowed. So if an employee were to be fired or otherwise treated badly because she stood up for her rights, to not be discriminated against, then that would be a lawsuit waiting to happen there. One example, I'm sure we come up with many, but one example is, let's say there's a woman, and again, I'm saying woman, but it could be another gender. Let's say there's a woman who is expressing milk at work, and she has a lot of colleagues who are maybe more traditionally minded and don't like that and think that she's not really working enough, and make snide comments at her, or maybe she puts the breast milk that she has expressed in the saving in the fridge, and there's a lot of comments around the workplace that's gross and that it shouldn't be allowed, and that they don't feel comfortable with seeing a woman's breast milk. That could give rise to a claim under the Maine Human Rights Act, and also the new federal laws too. Because an employee has the right to be in a workplace and not have to deal with that. I don't think that many people bring claims. We were just talking about that earlier with all of my fellow attorneys in employment law, and we haven't seen that many complaints for discrimination on that basis. So it could be that a lot of employees don't know about their rights, or don't want to enforce them, or don't want to create a problem. But it is important to to stand up for your rights, so that employers understand that they do have an obligation. And I also believe very strongly in education and communicating about these issues with workplaces, and having trainings so that these issues are resolved before, or these topics are discussed before there are issues. So we'll talk more, but I think there needs to be more of a push for workplaces in our state to talk very openly about these issues to their supervisors, their HR people, and their employees, so everyone's on the same page. There's also Title 26 of Maine law, which specifically states that a nursing mother in the workplace, needs to be able to receive adequate unpaid break time. So this follows what we talked about earlier with the Fair Labor Standards Act. And you can read the language there. There's a difference here. It says 3 years following childbirth. And as you might remember, the law before was 1 year following childbirth. It's just been amended to 2 years. But it will be 3 years will be what governs in Maine, because remember, whatever is the most protective to the employee is what will govern. So in Maine, a mother has 3 years, has a right to get this break time for up to 3 years following childbirth. And look at the words reasonable efforts. The employers need to make reasonable efforts to provide the clean room or other location other than a bathroom, and no discrimination. Okay, so I found this statistic as I was preparing for this webinar, but in May 2019, apparently 47% of new moms in the US cited that breastfeeding was one of the biggest challenges to returning to work. So that's sad. And then, the pandemic happened after that. And I've heard statistics about women in particular, being hit the hardest and trying to juggle it all. All right, let's talk about what's new, because I wanna make sure we leave enough time, and there's a lot to discuss here with the new laws. So what's new is that on December 29th, 2022, so not that long ago, President Biden signed the Consolidated Appropriations Act of 2023 into law. So what is that? It's a mouthful. Well, I'll explain it, but basically it had within this act, it had 2 employment laws that impact a nursing parent's right to pump at work. And that's what, we're here to talk about. These are the 2. So one is the Pregnant Workers Fairness Act. We call it PWFA for short. And the second is the Providing Urgent Maternal Protections for Nursing Mothers Act, or the PUMP Act for short. So I want to dig into this. And again, please write down your questions, and we can go back to any of these slides and discuss them more. So the Pregnant Workers Fairness Act expands what's already in the ADA, the Americans with Disabilities Act. And so it comes under the ADA, and it requires employers to provide accommodations to the language here is to individuals with known limitations arising from pregnancy, childbirth, or a related medical condition. And so this act really, it's not just about lactation, is it? It's about any kind of limitation arising from pregnancy, throughout childbirth and then afterwards. And so it's a little bit, the other one, the PUMP Act, is more focused on actually being able to pump at work. And it's also a different remedy process. So there's a different procedure for if an employee finds that their employer is violating the PUMP Act, they're going to do something different than and I'll explain that, than if an employee realizes that their employer is violating the PWFA. So I want you to understand the difference. The PWFA, again, is a requirement to provide reasonable accommodations when someone at work, when an employee has a limitation, they can't do their job like they did before because of something relating to their pregnancy, because they're pregnant and maybe they can't be around certain chemicals. There's probably a long list of examples of what an individual would need an accommodation for, or something related to the childbirth or after the child's born. And so this is different from what the law was, because being a pregnant person was not an ADA covered disability before. It wasn't so straightforward. So now it's very explicit, saying, okay, if this person's pregnant, they're covered by the ADA. They need to go through the interactive process. And the interactive process is something that it's a term of art legally that comes from the ADA, and it's just what it sounds like. It's an interaction between the employer and the employee, and it's a requirement legally that they work together to talk about what's the job look like, what's the problem, what's the potential solution, is there another is there a tool that you need to help you do your job, or is there another type of job that we can have you do for a temporary period? What kind of support do you need, in order to get through this issue you're experiencing? So it's not a one size fits all, because all of the issues out there vary depending on the job, depending on the person, depending on the medical issue or the problem. So what this law is saying is, if somebody is pregnant, or there's some issue that relates to their pregnancy or their childbirth that impacts their ability to work, then the employer cannot just fire them. They can't just mandate that the employee leave and say, okay, you're going to be on unpaid leave until you're resolved with your issue. There is the option to have leave be reasonable accommodation, but this law very specifically says that the employer has to try to find another solution if the employee wants another solution, and requiring leave, whether it be paid or unpaid, is a last resort option. So if there, and this part of the law actually is not going to go into effect until June 27th, 2023. And it also gives more protection. You can be qualified to have these protections, and whereas you might not have been qualified under the ADA before. They're making it very clear that this right is there. And there is an undue burden exception that I wrote here. And what does that mean? Well, if an employer says that what's requested by the employee would be an undue burden for them, they just cannot, maybe they're too small of a shop, they just can't do it. They really need that job filled. It's hard to describe exactly what that would look like, because it depends on the context, but there is an exception in the law that the employer doesn't have to give something to the employee as an accommodation if it would be an undue burden. That's a high standard for the employer to have to prove if they're challenged. And let me see, I have a note on this as well. So my notes are telling me that the EEOC, because this just came out, and again, it's not even going to be in effect until June, the EEOC is required to issue regulations on this and make the law a lot more clear. And they're, like, for instance, it's going to give examples of what reasonable accommodations look like, and that's expected to come out by the end of 2023. We don't have that yet, so keep your eyes out for that. But there will be more guidance on this later. And there's also a defense. The employer has a defense if they're challenged under the PWFA that they took reasonable steps to try to make it, to try to come up with an accommodation that would work. That will be a defense. The other law that I want to talk about is the PUMP Act. So for the PUMP Act, what this does is it amends the Fair Labor Standards Act. Okay, and it expands to all. When I say, what I mean by that is to all employees. Before, it was just the non-exempt hourly employees that had those protections, that they were guaranteed to have the break time that they needed to pump milk, and the private space. And now the PUMP Act is saying that this applies to everybody. It doesn't matter if you're exempt or non-exempt from the FLSA wage requirements. And then also what this law says is that all workers have the right to take reasonable unpaid breaks to express milk, and in the place that is not a bathroom, that's shielded from view and free from intrusion. And I said that there's some limited exceptions because, for instance, an an airline stewardess, like she wouldn't be able to take that right at this moment. There's some exceptions still because she's in an airplane, I guess. So more on the PUMP Act is that the protections, remember before it was 1 year under the FLSA, now this federal law says the protections for taking this break time to pump lasts for 2 years, beginning on the date on which the circumstances relating to the need arise. So that would be the childbirth, I'm assuming, but it doesn't always have to be. There could be other situations. There are some people who are pumping milk who haven't actually had the child. The law makes very clear, this particular new version of the law makes very clear that employees have to be completely relieved from work during these breaks. And you see pictures and you've seen examples of nursing parents working and pumping at the same time, right? They're pumping and they're on their computer. And if you're working at all, it's compensable time. Like you need to be getting paid from, for that work. If you're an exempt employee and you're not being paid by the hour, you have the right to not do any work during these breaks. And so, even if you're on a salary, so that's a right that is coming into effect with this new law. Unlike the other law, the PFWA that we talked about, the Pregnant Workers Fairness Act, which to bring a remedy for that, or to bring a claim, you have to exhaust your administrative remedies, just like with the ADA, by going to the agency in Maine. It's the Maine Human Rights Commission, and filing a claim there first. That's called exhausting administrative remedies. That's what you have to do if you have a claim under the PWFA. But for the PUMP Act, you don't need to do that. You can actually file a lawsuit in court without going to the Maine Human Rights Commission first. If you're alleging that your employer has not provided you with a private space to express milk at work, then the law requires that you give notice, preferably in writing, to the employer at least 10 days before you bring any kind of lawsuit enforcing that. And the reason for that is, and then you give the employer, if you're the employee, the opportunity to correct that, or to provide that private place to express milk. If the employer refuses to do that and says that they will not give the employee the private place to express milk, then you can go ahead and bring your lawsuit. And similarly, if your employer is not allowing you to be free from duties, or not allowing you adequate break time, then you have the option to bring a lawsuit and potentially get damages and even attorney's fees in exchange for that. Now, let's talk for a second about adequate break time, because there are going to be issues sometimes with employers not thinking that the employee needs so much time that they're requesting. And I don't have a great answer for that, other than it's a reasonable requirement, or it's a reasonableness requirement. So in analyzing if the employer did the right thing. So you can think of situations where it would be objectively unreasonable for the employee to ask for most of the day off, to do nothing except pump. There's some kind of a balance there, and the employer and the employee need to work that out. And of course, no retaliation or discrimination is allowed for any employee exercising their rights under this act, and they can bring a lawsuit if there is a violation of that. So what should employees do if they notice that their employers are not complying with the laws? They could file a claim with the Department of Labor, and the Department of Labor might conduct an investigation and issue a citation, or even has the ability to initiate lawsuits as well. Like we talked about, could file a lawsuit under either of those laws we talked about. That with the first one, you have to exhaust those remedies, but at some point you can file a lawsuit. Oh, for this one, sorry, I got confused for a second. For this slide, we're actually just talking about the PUMP Act, which does not require that exhaustion. So you can just file a lawsuit unless you have to give the 10 days notice. And the reasons, why you might file a lawsuit, again, we already discussed. Did your employer say that they're not going to give you the private space? And then you can educate others. It might be that people haven't heard about these issues or don't know about the new laws. And so I encourage you to talk about them and talk about this webinar, or point people, in a direction to educate themselves more, because this is the law now, and people need to get on board with it. So where we're going, right, there's still much work to be done, even though we've come a long way from the time in our country where women were only in the kitchen and not in the not at the conference table. But there's still a lot to be done, and like I said, the EEOC will come out with regulations that will have accommodation information in it, and also a lot of other information about how to interpret the new law and how to apply it, because this is brand new, exactly how this is all going to play out, and everyone's learning together about it and what it means. Employers, need to educate their management and their HR teams and their employees, to ensure compliance, and also to move workplace culture away from some of the attitudes that are stuck in the past. Right. And I know at my law firm, we do trainings, and I think that's really important. And I have a lot of other friends who are employment lawyers who do trainings, and we go in and talk to the workplace, to the supervisors, to the employees about what these laws are and why they're important, the risks of not complying with them. And that kind of communication up front can go a very long way in helping change the attitudes in the workplace to be more accommodating, and to be, a better place for moms to be and to feel supported, and to be able to give their children what they need in terms of breast milk. And then also, employees need to stand up for their rights. Right? If that's how you make change, by bringing claims, and if something's gone wrong, they need to stand up, for what's right, and initiate that conversation, because that's how change happens. So now I've left 15 minutes. So Kara, I did better than we talked about, which is great. I'm just going to open it up for discussions, and for any questions or any discussion about these issues. If people have examples they want to talk about with the group, just feel free. Actually, Kara, let me ask you, what do you think the best way is to go about getting people to talk? Because I know we have quite a few participants.
Yeah, I think we have a few questions already in the chat box. I don't know if you can see those, or if you'd like me to read them, I can do that as well.
Yeah, I haven't looked, so why don't you read them to me, and
sure.
I'll take it.
Yeah, thank you so much for this. So let me see if I can get to the first one. Dr. Criswell is asking, is this for all sized companies? And she may be referring specifically to the PUMP Act, but if you can answer for both the Pregnancy Fairness Act and PUMP would be great.
Yeah, absolutely. So yes, for the PUMP Act, let's see, let me go back to one of the slides.
And for anyone else who has questions, please feel free to type them in the chat box. And you're also welcome to unmute when once we've gotten through the questions in the chat box, and you can ask that way as well. Yeah.
Thank you for asking the question about employees. So for the PUMP Act, because it amends the Fair Labor Standards Act, that applies to all employees. And so that doesn't matter how many employees your employer has, but for the PWFA, it is expanding the ADA, the Americans with Disabilities Act, and that does have a requirement of 15 employees. So, so it wouldn't apply to employers who have fewer than 15 employees. But there are, state laws that are more protective, and so, in Maine, you would still be protected. You just if your employer had fewer than 15 employees, you could bring a claim under, potentially under the Maine Human Rights Act, because that applies to employers that have fewer than 15. I hope that answers the question.
Yes, thanks.
Another one?
Thanks.
Sure.
Yeah, and one question that might come up is whether or not these slides would be available for folks to have access to, or if there are other resources that specifically for the resources as well. And we will have the recording on our YouTube page, which we will also link on our website. And if you have any other resources that you'd like us to add to our website, that would be great.
Yeah, definitely we'll make this available. Anybody who wants a copy of the slides can have that, and yes, it will be available afterwards.
Okay.
And there's great resources on the EEOC's website. I would point people there, and also the Department of Labor, well, which is part of the EEOC, but Maine's Department of Labor website as well could be a helpful resource. So there's lots of Q&As or FAQs, I should say, and on those websites that you might want to poke around, and there are fact sheets that come out by the DOL that can be really helpful. And I know that there's some about these issues, and probably will be continuing to come out. As I said, these are brand new.
Yes, excellent. I just put our resource library link in the chat too, and you can navigate through that by clicking on the categories at the top too. There should be some resources at the bottom regarding this. So another question from Robin, and she quotes, beginning on the date ... circumstances arise, unquote, would that be the day they go back to work and need to pump?
Well, that's something that I haven't seen that interpreted yet. Not that it hasn't been, but my take on it, without looking into it, is that it's probably from the date of childbirth, because that's when you might need to, start breastfeeding and pumping, but it also could be the date where you need to express milk. So I would need more clarification on that. And that's, even the lawyers I was talking to earlier were talking about how there's some confusion already with this new language. So we're hoping that the EEOC's regulations are going to clarify some of what all this means.
Okay, excellent, thank you. And Cassie was sharing that it took her at least 20 minutes each time she pumped, typically with more time to clean supplies. And I think for a lot of us, I think the majority of us who are here today work with families who are returning to work and they have questions and they're looking to us for support and guidance. And I think we'll often say to try to plan on a 20 to 30-minute break to a few times a day for at least the first few months returning back to work. And that seems pretty reasonable. I'd be curious if other people have experiences working with people who have asked for more than that. And I think that you helped clarify the reasonable time piece is a tricky piece, right? Like, what is reasonable? And you refer to something as reasonableness requirement. Is that a law term?
Yes. So that's also why you've heard me say a few times these EEOC regulations, and they're probably going to talk about accommodation examples. We do have some idea of what reasonable means, and when it comes to time, and also what the accommodations would look like, but that will continue to develop, as case law develops, as regulations come out. It's really hard to answer that question because this is like a ever-evolving organism in a way, and what is reasonable can change depending on the situation. But like some examples for reasonable accommodations for lactation could include, I wrote this down, the schedule changes or flexible work, or light duty, or remote work, or perhaps a change in job duties to avoid toxic chemicals that could enter breast milk, right? There's all kinds of things that could come up that an employee needs as an accommodation and requests. And then it comes down to that interactive process of of the employer figuring out if that's going to be an undue burden or not, if that's reasonable. And then if it gets challenged, right, if the employee ends up bringing a claim that they were not given a reasonable accommodation, the fact finder in that challenge is going to examine what the employer did. And like I said, it's a defense to that claim if the employer can show that they took steps to try to work with the employee to understand what the needs were. And, so effort and communication and having things documented, right, is important too, because if it gets to the place of trying to talk about what happened and was it sufficient, it's really a lot easier if you have documentation about what was communicated versus just he said, she said. And so I always advise people that if they have a conversation in person or on a Zoom call or something, which is better than just emailing, to try to follow up with a summary in writing of what was discussed and agreed upon, because it's just better for both parties to have that, and also could become relevant if there was ever a claim. So the answer to what is reasonable is hard to say. And there's, going to be more guidance on it as time evolves on and we get more decisions.
Mm-hmm. Yeah, that's great. That's helpful guidance for us to offer families that we work with to be keeping documentation about these conversations. Well, first to have the conversations with their employers, and to, we're working on an employee guide to return to work, and an employer guide we'll be working on this fall that will include different aspects to that return to work that they can be talking about. So some communication guides included with that. Miriam, I'm going to go back to your question in a second, but this kind of leads into Sandy's question, wondering about how the PUMP law impacts school site settings where teachers leave their classroom to a quiet space. Is it undue burden for school sites to provide a substitute during pumping sessions? That's a great question, Sandy. I think I would say education and healthcare settings can be especially tricky for getting that time in that space to pump, and providing a substitute during pumping sessions. I think some schools could argue that is an undue hardship, but I don't know enough about what is considered undue hardship. So any thoughts on that?
I haven't looked into that particular question in the school setting. So I don't know the top of my head if there's already guidance on that question, but there probably is. I just don't know it. So, but it goes the way that these questions are analyzed are by looking at the context and what has been done in similar contexts as well, and also like the resources of, in this case, the school, what's possible. And I don't have enough of that information, but in theory, it sounds like a good idea to be able to provide a sub during that time. It sounds like it would be reasonable to me.
If they can find a substitute, knowing that schools have a hard time finding
Right.
substitutes, and they have a lot of people covering each other's classrooms for a lot of different reasons. But that's a good question, and it's a real challenge. And then that also kind of connects to Haley's question. Are there laws that employers can enforce about pumping in front of another employee, like saying you can't pump at your desk?
Is the question, sorry, I'm not sure I understand the question exactly. Can you to help me?
I'm not super clear either. Haley, are you able to unmute by any chance and ask that question again?
Yeah, sorry. I guess my question was more so if an employee wanted to, work through the day and just pump at their desk, are there anything that the employee or the employer could say to the employee, like, hey, you can't do this in front of other employees? Like, are there any laws against pumping in front of other employees at the workplace?
There's no law about that. There's no law that says that employees are not allowed to pump in front of other employees. So the law just says that the employee has the right to a private space that's free from intrusion. And And so, if the employee wanted to pump in front of other employees, then the other employee had a problem with it, it would be part of that interactive process and conversation at the workplace. And at the end of the day, I think what would need to happen is that the other coworkers would need to be okay with it and not be discriminated, because that could become a discrimination claim pretty easily, I think. So, it would be up to management to really have these conversations and see if because obviously there's business reasons, like if it was actually disruptive and it didn't have to do with discrimination because somebody was uncomfortable with the idea of it, but rather it might impede on like a phone call someone needed to have because the pump machine was really loud. If it's something like that, then I could see the employer having the ability to say, okay, we need to come up with a solution here so that this other work of this person can get done without interruption. How about you do this? So that's why reasonable is the standard. It really depends on the circumstances, and that kind of interactive dialogue and problem solving needs to be happening in each workplace. But most of the time, people are going to want to have their private space to pump, which the law allows.
Thank you. And Miriam's question is, what about for people who are classified as temporary workers? And she was thinking of all the workers at Abbott. Would they have any rights?
Yeah, temporary workers have these rights as well. That, like I said, the PUMP Act, for if you're talking about the right to the break time, the reasonable break time, and in the private place, there's no requirement that you work so many hours in order to get that right.
Okay. That's helpful. Thank you. Other questions? You're welcome to unmute or type it in the chat box.
I think we have time for maybe one more. I'll check my notes too in case I forgot something.
Yeah. That statistic about, you said 47% of workers said that breastfeeding was the biggest challenge to returning to work. I will often cite something similar, but almost switched around, that one of the bigger challenges to breastfeeding is returning to work. And that is something that I will often cite when giving testimony for paid leave, for instance. I'm not sure why I just gave a thumbs up there, but so
no, that's yeah. And what do you think, Kara, about moving forward? And you're more in this world than I am. So what are some of your thoughts to maybe end this presentation with what needs to happen to continue to see improvement in this area?
Yeah, thanks. Great question. I think staying involved with the Maine State Breastfeeding Coalition or your local coalition or state coalition, if you're not in Maine, is going to be key, because we will be keeping up with any sort of bill that might be related to this, but also just so the families that you're working with are often asking you questions about what are their rights. And we have that information on our website that you can share with people if they have any questions about and we get these questions several times a year about whether or not they have a case, or if they, what else they can ask their employer, what are their rights. We will help them with that. And we know that we can connect with people like Attorney Tozier to take those further steps, since we aren't attorneys. But yeah, staying in touch with us, and then and helping the families advocate for themselves by giving them the information and connecting them with the appropriate people. And then in terms of other advocacy measures, paid leave is just such an important one that we're advocating for, so that they can have as much time off before they have to return to work.
Right, absolutely. And I'll add to that. I think a lot of times when employees don't know about their rights or what the laws say, and it's not usually a situation where there's lots of people in the workplace that have just had a child and are needing to express milk. So sometimes employees probably can feel quite isolated and alone and singled out. And so to be able to talk about this more openly and to feel camaraderie around it, and to make it more of a point of discussion, this is this is what just passed. This is important to our country. This is important to our state. This is, there are legal rights. Like there are remedies that employees can get, and penalties for employers to have to endure if these laws are not respected, are not followed. And so that's very serious, and it's important for people to feel emboldened by that and talk to each other, and make this not a taboo subject at all, and encourage this, because it is important for employees to feel supported, and like they can do both, and they have support for that and can get accommodations for that. And here's my email address and my phone number and my law firm. If anybody wants to reach out to me after today and talk to me more, or talk to me about doing trainings or becoming counsel. I do a lot of coaching of workplaces and HR departments for all kinds of issues relating to employment and how to handle issues at work. Please reach out and I can help you or connect you to whoever you need to talk to. So thank you very much for having me.
Thank you so much. Have a great day, everyone.
Thank you.